Sale of land in installments, beware. These days it happens quite often that the purchaser wouldn't obtain a loan financing from the bank. So the seller and the purchaser would then often negotiate and agree that the purchaser will pay off the purchase price in installments to the seller. In other words, the seller basically is acting like the bank and gives credit to the purchaser so that the purchaser can pay off the purchase price in monthly or other installments to the seller. Now, I think the most important thing to point out in this regard is that you need legal advice before you enter into an agreement of sale and its installments. And also as a state agent, please make sure that you consult an attorney and get an attorney involved to draft the agreement. For example, if it is a residential property where the purchase price is paid in more than 2 installments over a period of more than a year, then Chapter 2 of the Alienation of Land Act would be applicable. And certain requirements have to be met to ensure that the agreement is valid. Also, if it's paid in installments, then it might mean that the National Credit Act is applicable. Let's say you have agricultural land, a farm that is being sold, then you quite regularly get a situation where the purchaser can't get a loan from the bank, and then the parties agree once again that the purchaser will pay in installments. Now, where such installments are paid together with interest, or in certain cases, even if there is no interest charged, but there is a bond registered as security, then the National Credit Act would apply. And then once again, certain requirements of the Act have to be met to ensure that the agreement is indeed valid and enforceable. For example, in many cases, there might be the obligation of the seller to register as a credit provider in terms of the National Credit Act. So that needs to be done within a certain period of time for the agreement once again to be valid. It also means that there must be a quotation provided to the purchaser in respect of the costs and the interest implications of the transaction before he signs the agreement to ensure that he does indeed take an informed decision. Otherwise, once again, the agreement won't be valid and enforceable. So unfortunately, as soon as the National Credit Act does apply, the additional requirements and consequently additional cost implications that you should keep in mind. Also, where it's an installment sale agreement, the problem always is when would you as seller transfer the property to the purchaser? Because if you transfer it immediately after the contract is signed, then the seller obviously takes a big risk because he does not yet have the money that the purchaser has to pay in respect of the purchase price. So if the purchaser later fails to pay the installments, then the seller has to sue the purchaser. Purchaser might in the meantime pass away or be declared insolvent, etc. And then you certainly sit with a big headache as a seller. On the other hand, if you only transfer the property once the full purchase price has been paid by the purchaser, then the purchaser takes a big risk in that he pays all the money to the purchaser before he has become the owner of the property. And once again, if something happens to the seller, if he, for example, passes away or is declared insolvent, then the purchaser stands the risk of losing all the money that he was already paid, as well as the property, because the property is not yet registered in his name as the owner. So both these scenarios are certainly not the best ones to follow. What we would typically do is the following, is to ensure that in terms of the agreement, the purchaser does pay a substantial deposit in respect of the purchase price, let's say 10, 20, 30% of the purchase price, and that amount is then upon registration paid to the seller. In other words, it's first held in trust by the conveyancer, and then only after the registration of the property into the name of the purchaser is it paid to the seller. But then together with the transfer of the property to the purchaser, we would typically register a bond in favor of the seller as security. Just like you could register a bond in favor of the bank as security, you can also register a bond in favor of the seller as security. So if the purchaser then later fails to pay, then at least the seller is protected in that he has already received the deposit in respect of the purchase price, and that he has a bond registered of the property as security. So the seller would, in such a case, enjoy preference over any other creditors, so should something happen to the purchaser. The purchaser, on the other hand, is also protected, and that he would really take transfer of the property and be the owner thereof. So even if something happens to the seller, death or insolvency, the purchaser is protected in that regard. So once again, please make sure, as estate agents, particularly if you're involved with a transaction where the purchase price is paid in installments, make sure that you get proper legal advice so that all the relevant requirements of the relevant legislation is complied with.